Opportunity to be here. What I wanted to do today was sort of maybe three things. One is I'm going to walk through the slides that I have that are designed to talk about a national privacy law and how we've got to this point, what sort of the status quo is, and what some of the issues are going forward about a national privacy law. Then I am going to leave plenty of time. I am happy to take questions, I guess part two, about anything I've covered today. Frankly, anything else in the privacy law space. If you have questions about other topics, I will pretend to be able to answer them, at least give you some sense for just about any question you can probably come up with. I am also happy to take questions from the group about privacy law, careers, things like that, career questions if people do have those things as well. So don't hesitate to ask. Please think about your questions. And again, I'll try to make sure I've left plenty of time for that as we go forward. So why don't we go to the next screen, please? So we have been talking about a national privacy law in the United States since the mid-1990s. I realize that many of you were not even alive at that point in time, but we've been talking about that, and we've had very little progress on that. We're having, however, right now a more active debate than we've had, I think, at any point during that period, or at least certainly since we started the debate in the 1990s. There is still probably a long ways to go on that. We'll talk about some of the dynamics and some of the issues that may influence that timing. But there has been meaningful progress in the direction of a national law, and there are some consensus concepts that are building towards what that law might say. There is a parallel development, as many of you may be aware, in other countries outside of the United States. Those laws are becoming more voluminous and more complicated, and the relationship between international laws and the United States is causing problems in the United States for companies who want to bring data into the United States from other countries. And so that's it's a parallel development that is influencing at least part of the United States debate. We're going to talk a little bit today about developments at the state level. Those developments are both important on their own and important as a driver of the national privacy law. I think it is fair to say that developments at the state level have been somewhat slower than many of us anticipated. There have been some very recent developments on that front, and in fact, these slides that I did about 10 days ago are now outdated already on the state law level, so I will mention that. But we'll talk about why the state law is important, what you should be focusing on that. So there's a couple of issues that are occupying most of the attention in the national debate. I'll mention those so you're aware of what they are. My concern is that as this debate proceeds, that those couple of issues are taking up 90% of the attention, and that means that the real substance of the privacy law isn't getting enough attention, which is a problem. So let's go to the next slide, please. So background, just for those of you who haven't yet taken a privacy law class. Hopefully many of you have, or at least will. There are a couple of privacy law classes at Georgetown that I'm hopefully going to be doing some guest speaking for, so that will be that's always fun. But just to set the stage, there is a large and growing number of privacy laws and regulations at the state level, at the federal level, and at international levels. In the United States, different from most other countries, those laws have been either specific by industry segment, banking, financial services, healthcare, education, or by particular practices like telemarketing. I should probably add a third category, that there are some laws dealing with particular kinds of data, biometric data, genetic data, for example. But today, you need to understand that there is no generally applicable US privacy law that covers all industries and all data. Because there are so many different laws, there is increasing complexity of the regulatory environment. I will build the case for you today that that is both bad for consumers and bad for businesses. The only people it is good for are privacy lawyers. I am thankful to be in that number, but we are not a group that is deserving of public policy attention on our own. So I do think there are some changes that would be for the better of both consumers and businesses. And I think that one of the issues that students should be thinking about in this area is that privacy is often positioned as an either or. It's for the benefit of consumers or companies take advantage of it, but there are some elements of that where there is at least a win-win. On top of the laws that exist, we also are seeing real concerns about things like big data, artificial intelligence, use of algorithms, potentially discriminatory effects of those issues. And we're seeing more and more concern about unregulated data in the United States. Even though we have so many laws, there's lots of data that is in fact unregulated. Let's go to the next slide, please. On top of all of this, we've had COVID-19 developments. This has highlighted a couple of challenges in not only US privacy law, but particularly in US privacy law. It has highlighted the impact of privacy issues involving employees, where there are few direct laws. I have spent, in the early days of COVID in particular, I spent more time learning about the Americans with Disabilities Act, which is not usually a privacy law and not usually something that privacy officers and privacy lawyers paid attention to, but it became the primary law that regulated what employers could do with employee information about positive tests and the like. COVID has also highlighted another weakness in how we think about privacy law. This is not only a US issue at all. Most privacy laws that we think about, for example, the financial services law, just to give you one example, regulates what a financial service company can do and what the rights of the consumers of the financial institutions are. It's sort of a bipartisan look. It's a two-way issue. It's company and their consumers. But COVID-19 has added the fact that there's lots of other people who now have interest in your personal data. It's not banking data, but if you are a person who tested positive and go back to your workplace, not only do you and your employer have an interest in that data, but your coworkers have an interest in that data. If you go to a hotel and you're a guest there, not only does the hotel have an interest in your data, but the other guests have an interest in your health and your data. So it's highlighted that we don't really have laws to deal with that kind of issue. We don't really think about third parties and how they get involved in this. So the COVID debate has made the discussion of privacy law even more complicated. Not that it needed that extra complexity, but it has certainly made the law even more complicated. Let's go to the next slide, please. So a couple of things to think about as you think about a national law, consider that in your courses, think about it from a policy perspective, et cetera. Many of you have probably heard about the California Consumer Privacy Act, very important law. It is described in the media and otherwise as a comprehensive state privacy law. However, it's not a comprehensive state privacy law. It has all kinds of different provisions and all kinds of exemptions. And I want to just give you one example, which is health information. I don't know if anybody on this call is from California. If you happen to be a California resident, under the CCPA, your health information is regulated by at least 6 different regulatory schemes. There is information about your health that is regulated by the HIPAA rules, which are the primary federal rules for the healthcare industry. If it's covered by those laws, it's not covered by CCPA. There's a California mini version of HIPAA, which applies in California. If it's covered by that law, not covered by CCPA. If you're involved in medical research, COVID research, or any other kind of medical research, that's carved out of CCPA because there's a separate set of rules dealing with federal research activities. Then we have the CCPA itself, which is designed to fill some gaps, but then CCPA doesn't cover nonprofits. Think of all the patient support groups and the consumer groups and just all kinds of nonprofit activities that have healthcare information. They're not covered by CCPA. They're probably not covered by any of these other laws. And CCPA generally doesn't cover information about employees that's held by employers. So if you're a consumer in California, it is fair to think that there's no possible way you're going to figure this out. I mean, I teach healthcare privacy law, and I do not expect my students, I would like them to understand all this. I don't really expect them to understand all of this. And so I think in California, we are at a position now, particularly if you're dealing with healthcare information, but not only, where it's a lose-lose. The consumers are confused, the consumers can't understand it, and the businesses can't figure out what to do. And the businesses have to set up different sets of rules depending on where their information is coming from, who it's going to, what lines of business they're in, who their business partners are, et cetera. So I think that's actually not a useful situation. Lots of people don't necessarily agree with me or view the California law as useful because it fills certain gaps. But I think you should understand that that's really all it does, is it fills certain gaps. That doesn't simplify things necessarily. It doesn't make it easier to understand, et cetera. Let's go to the next slide, please. Another model, and again, it's just a different example, is how privacy law works in the European Union. GDPR, which is the very broad, relatively recent law in the European Union, is in fact a one-size-fits-all privacy law. It protects all personal information in all settings. That means your data is protected, health data or any other kind of data, regardless of who has it or the context in which they have it. There are certain categories of sensitive data where you may get additional rights, but in general, it's a one-size-fits-all privacy law. What that means, however, is that there's no detail and there's no nuance to deal with particular situations. The healthcare rules in the United States, for example, have a tremendous amount of nuance for the healthcare industry. The premise of the healthcare privacy rules is A, provide reasonable protection for individual privacy, but B, and this is an important B, also make sure the healthcare system works pretty well. And so there's lots of details that are built into the HIPAA rules that are designed to make the healthcare system work well. None of those details are built into GDPR. It's a broad brush that doesn't treat anybody differently, doesn't treat any, doesn't try to come up with situations that are specific to an industry. That's not a recommendation. It's just an alternate model. California, lots of details, lots of exemptions, lots of specifics, lots of narrow applications. GDPR, very broad across the board, doesn't really distinguish different settings. So let's think about that, and then let's go on to the next slide as we move on to the national debate. So we should be thinking at a national level, what is the right approach in the United States? Should there be an overall approach to privacy, or should we have something that is tailored to more particular situations? Again, CCPA is very, very specific in lots of settings. We also have other laws that are coming up in the United States, things like facial recognition laws, which are designed for very particular purposes to deal with particular risks associated with facial recognition. For example, we don't have, in lots of other areas of privacy law, we don't have concern about the use of facial recognition to misidentify potential criminal suspects. That's just not an issue that comes up in other settings, or if there's a mistake element, we don't care about it. If you're supposed to get one kind of ad and you get a different kind of ad, nobody cares about that. If you're arrested because you happen to look like somebody else, that's a real problem and we have to be concerned about that. So our current laws deal with lots of different topics, lots of different data categories, lots of different industries. And again, you could definitely take the position that that's the right way to do this. We seem to be moving to a point where we've said, no, we need a general law, but that's still very much part of the discussion, something we're going to be thinking about. So let's go to the next slide, please. So some of the key issues that we are thinking about at a national level as we look at a national law. The first two bullet points that I have here are by far the two most important topics as far as the debate is going on today. I'm not necessarily saying they are actually the two most important topics, but these are the topics that have occupied almost all of the attention of discussion at the federal level. First is preemption. Let me be clear what preemption means. Preemption means, will the national law take precedence over the state laws? And so that is a real debate right now. There's both important philosophical questions there and important, like, real practical politics issues. Practical politics, meaning if there's going to be a national law, it's got to get through the House of Representatives, where there are 45 California congressmen, all of whom think that the California law is something that should be preserved, or at least most of whom think the California law is something that should be preserved. So whether the federal law will create a single national standard or will simply create a law and let the states also do what they want to do is very much up in the air. As a broad general matter, the Republicans seem to favor preemption, the Democrats don't, but that's not a hard and fast rule at this point. The second topic is whether there will be a private right of action. Will consumers be able to sue for violations of the federal law? Also a very important issue. Similar partisan split. Republicans do not support a private right of action. Democrats generally do support a private right of action. I'm not sure where we're going to end up on either of these points. I think lots of people are looking for some kind of a common middle ground. There may be a middle ground in the sense of giving the regulatory agencies ability to sue for consumer injury, which they don't really have now. There may be efforts to let the states in the Attorney General's offices actually sue and investigate for violations of the federal law, and in that way let them have a role even if their law is preempted, but that's very much open for discussion. But those are the first two topics. I want to mention some of the other topics that I think are critical to whether a law is actually going to be a good law, but we haven't been spending a lot of time on this. One is, what's going to happen with all the other federal laws? Preemption only deals with state law. You don't preempt federal law. So we have HIPAA, we have Gramm-Leach-Bliley, we have FERPA for the education industry, we have the telemarketing laws, we have tons of federal laws. What's going to happen to those laws? Most of the proposals at this point just continue them along. But that means in healthcare, for example, we have different sets of rules. If we pass a federal law that carves out HIPAA, we will have different sets of rules for the same information depending on who has it. That's not inherently a bad thing, but I'm also not sure it's inherently a good thing. So that's a real question. The scope of individual rights that will be available to consumers. Individual rights are very important under GDPR, very important under CCPA. That's a right to get a copy of your records, right to amend them, a right, various rights that you have. We're going to see how many rights will be built into the federal law. We are looking at the question of whether we should change the underlying approach to privacy law. Today, most US privacy law is governed, and again, this will be familiar to anybody who's taken a privacy law class. It's governed by the idea of notice and choice. You are given a notice when you go to a website, when you go to a doctor, when you open a bank account, you're given a notice of that entity's privacy practices. You may have some ability to influence what they do based on your own choice. I know that all of you are dedicated, serious law students, and therefore you read every single privacy notice that is presented to you at every single website to go to, but we all know that that's not true. So there's a real question as to whether that approach makes any sense today. There are lots of people who believe it doesn't. So we're looking at alternate models. There may be ways of saying, sort of instead of saying to the consumer, as long as the company tells you what they're going to do, they can do anything they want. We may start to set some rules on what they can and cannot do in the first place. We're thinking about that. Enforcement is another issue that we're paying a lot of attention to. What kind of enforcement opportunities? Who will do enforcement? Right now, excuse me, we have a variety of federal agencies that enforce each of the specific laws. We have the Federal Trade Commission that's sort of a default regulator, but the FTC doesn't have a lot of authority at this point. So there's a question as to whether the FTC will continue to be the primary regulator. Will the FTC be given new powers, new enforcement authority? Or will we come up with a whole different agency that's a data protection agency like they have in Europe? Very much an open question. Let's go to the next slide, please. Other issues. How are we going to deal with innovation? Both in terms of how we define the data that's going to be covered, and the business community always thinks that privacy laws impede innovation. Now, to be fair is not the right word. To be clear, they say that all the time, whether it's true or not. And they say it so automatically that it's not clear to me that anyone actually believes that the tech community anymore on this, but it is a relevant consideration, at least to some extent. How we're going to define personal data is important. What personal data was in the mid-90s was very different than what we think of it today. We didn't have mobile devices. We didn't have the same kind of online advertising. We didn't have things that tracked you across your laptop and your iPhone and your iPad and your desktop computer. We didn't have facial recognition. We didn't have a lot of the biometrics, et cetera. So the California law includes my favorite category of personal information, which is it regulates the use of olfactory information. I'm not entirely sure what that means. That seems to mean that companies aren't allowed to track you based on your personal smell. I don't know whether that will eventually be something that is a real thing, but it's in the California law. They're trying to future-proof it. On a little more less significant but very important kind of issue is, will it include things like employee data? Many of the laws carve out employee data and view it as consumer-oriented. GDPR, by contrast, absolutely covers employee data. Are we going to protect certain kinds of sensitive data? And if so, what is that? In the EU, sensitive data includes things like health data, but it also includes racial and ethnic descriptions, religious affiliations, even political affiliations, and whether you're a member of a union. Those are not necessarily topics that we view as particularly sensitive, at least for privacy purposes in the United States. So we've got a real question as to whether we're going to deal with sensitive categories of data. What is the intention of the US law towards international principles? Right now, there are significant challenges for companies doing business internationally, particularly in the European Union, because the European Union does not believe that European Union personal data can effectively and safely travel to the United States. That's obviously a problem if you are a US company that has offices in Spain and France and Germany, and you can't send data even about your employees to the United States. That's a big problem. So we're looking at that issue. How we're going to deal with discrimination, artificial intelligence, et cetera. Obviously very important issues. There's a real question in my mind as to whether a privacy law should deal with these issues. We historically have dealt with things like discrimination through civil rights laws, not privacy laws. We've dealt with things like bias in, unfair treatment under insurance principles. We've dealt with that in insurance law, not privacy law. So it's a question in my mind how we're going to deal with it. I think these issues are really complicated. My personal concern is that the privacy law issues that we have to deal with are already complicated enough. If we add in all the ideas dealing with discrimination and artificial intelligence, I'm concerned that we're not going to get any of it right, but it's a real question. Couple of last minute things to mention. Are we going to deal with data security issues in this law? There are laws dealing with data security. We don't really have a single national law. We could include that in this law. Most of the drafts at this point do not cover that. Security breach notification. There are laws in each of the 50 states and the District of Columbia dealing with data breach notification. As somebody who has to deal with those laws almost every day, I hate dealing with 51 state laws that are different on useless things. I would love to have a single national standard. Open question as to whether that's going to come into the law. And then there's a question about whether we're going to treat a particular category of business differently, which is data brokers, people who collect and combine and aggregate data from all kinds of sources and usually then sell it on to other businesses. There are certainly people in the privacy community and the regulatory community who believe that a lot of the privacy concerns that we have are driven by the activities of data brokers. They haven't historically been treated differently than others, but we may see that going forward. Let's go to the next slide, please. So, a couple of state law developments, again, just to set the stage. We have CCPA, the California Consumer Privacy Act, went into effect roughly a year ago, January 1st, 2020. Enforcement could not begin until July 1st, 2020. We haven't really seen enforcement of CCPA yet. We have seen a little bit of litigation over CCPA, but not much. California likes to make sure that nobody actually understands what's going on in California. So while that law is still being evaluated and implemented, they've also passed a new major amendment to CCPA called the CPRA, which was a referendum that was approved by California voters. That will go into effect in 2023. Again, very disruptive, very confusing. Other states have been looking at state laws, but we haven't seen them for the most part. Washington state got close in 2019, got close in 2020, hasn't yet passed a law. New York, Oklahoma are looking at laws. Virginia, out of the blue, looks like it's going to have passed a law. They have a bill that has now passed both houses of the Virginia legislature very quickly. I'm reading that law for some presentations tomorrow. I'm finding all kinds of problems with the law, but they did pass a law that looks like it's going to be finalized. One of the challenges is that the California history of how their law went into effect is bizarre and unique, and I don't think that other states are going to either replicate their process or replicate their substance. So that means that states, even if they want to pass a law, don't really have a model yet to work with. Let's go to the next slide, please. California, however, is very much driving the national debate. The industry is concerned about the California law on its own. Industry is very concerned about other states passing California laws, even if they don't look like California. Some companies are concerned about global efforts and would like to see a US law that meets global standards. That is a small number of companies at this point, but it's a small number of very important companies, Microsoft at the top of that list. So California has a lot of influence on the national debate, but we're still waiting to see how that's going to play out. Let's go to the next slide, please. Some things to watch for. If states start to move, will they follow the California principles? I don't think they will, but that's an open question. If they're not going to follow California, are they going to follow some other model? I've been curious about this Virginia law because it was able to get through their process so quickly. States may look at that and say, that seems to be a law that lots of people in Virginia supported. Maybe that's a good model. Again, as I dive into the law, I don't like it as a model, but that doesn't mean it won't become a model. Lots of, how much movement are we going to see this year on a federal law? Very much an open question. Will some of those other elements that I mentioned be incorporated into the law? I also think that it's going to be really interesting to watch what happens with the other federal laws, whether we will see them replaced, supplemented, amended, etc. Let's go to the next slide, please. Couple of federal wildcards. One is that there's been recently in the last, I'll say 2 weeks, introduced a specific privacy law dealing with COVID issues. It's mainly dealing with contact tracing kinds of ideas. That bill was introduced in May of last year also. At the time, lots of people, myself included, thought it was going to pass. It didn't, for reasons that I can't really explain. It's been reintroduced this year, pretty strong support. I think there's a decent chance that that law will pass. Two big issues coming out of that law. One is, will any of the principles of that law be applied to a broader national law? Second, and this is my real out-of-the-box prediction, Congress loves to add stuff at the end when bills are ready to get passed. I am curious if this bill gets to a point where it's about to pass, whether one of the senators or congressmen who has introduced a privacy bill will throw their privacy bill into this COVID bill. That would be an interesting way to shortcut all the other legislative debate. I don't expect that to happen, but I'm watching because that wouldn't astonish me. Another variation, which is a way that it could be added to a COVID bill without a lot of the complications, would be to pass a very limited federal law, one that may be dealt only with preemption and a private cause of action, and then basically said to the FTC, go write a regulation that figures everything else out. I personally would be perfectly supportive of that. I'd much rather have the FTC looking at all these complicated issues than having Congress try to figure them out. I don't know about you. I'm not that optimistic about Congress's ability to do a lot of this detailed, thoughtful substance, but we'll see. We're going to watch that. All right, next slide, please. My predictions. I think the odds go up of a privacy law in 2021. Obviously, we assume that the Biden administration will be more supportive of a privacy law than the last administration was. But at the same time, it's not number one on their priority list. It's not number two. It's not number three. It may not be number 10. There are some open issues about the administration's interest in this because Vice President Harris actually had a very significant role in the development of California privacy law when she was Attorney General before she became a senator. That doesn't mean she's going to get involved in this, but she might. I personally think the major driver of what's going to happen at the federal level is actually what the states do. My prediction is that if 3 to 5 states pass something like California, it doesn't have to be exactly like California, but pass a general overall privacy law, then I think corporate America has to get behind some kind of federal law. And I think that push becomes a tipping point on the federal law. That doesn't answer the questions of what it's going to say. I just think that companies aren't going to be able to deal with 3 to 5 different state laws, particularly if they are different state laws. Virginia may become the first of those 3 to 5 states. I'm not sure where the other 3 to 5 are going to come from. My prediction is that there's going to, and I realize there's a typo on this bullet point that I've used in December. It's now not quite accurate. I think there's more than a 50-50 chance, reasonable likelihood that there will be a privacy law during the current presidential term. But that means before January 2025. That doesn't mean this year. So I think the state law will affect the timing of that. Tremendous open questions on what that law is actually going to do, how it will work with state laws, how it will work with other federal laws. But I think we're moving in that direction slowly and probably surely, but we'll see. So I think